Hi, we're live as opposed to dead. Obviously this is a recording. My name is Richard Elslager. I am an attorney in Chicagoland, and I have a practice area specifically in personal injury, but I handle a variety of other areas of law. And I'm a gearhead, so I particularly like the automobile. I like sports cars. I like old cars like Shelby Mustangs, as you might see from the painting or the illustration behind me. I also like cases that involve automobile type litigation and anything that's associated with cars. So that's the purpose of my web channel, is to convey to you basic cases, case law that's out there throughout the states on a multi-state level. Anything that involves a car, anything that involves a car mark or car design, an auto accident, accident at a racetrack, just to bring to you the law as it pertains to auto accidents and anything automotive related, and how the law interprets this sort of thing. So let's begin. Let's get this started. First case that I'm going to discuss today, and I'll be discussing it for a brief period of time. I won't be too verbose, hopefully. But this is a case known as Automobili Lamborghini SPA versus a certain restaurant in Las Vegas. So this case arises out of a trademark infringement. The facts of the case were that this restaurant, which was also a retail shop and an automobile gallery at the Palazzo Hotel and Casino in Vegas, decided to use a specific logo that that represented their brand. And a picture of the logo is here. I don't know if you can see it very well in the camera as it's running, but the logo does seem to bear a bit of a resemblance to the Lamborghini logo. So Lamborghini apparently got really hot and bothered about this, and they were very upset, which resulted in this litigation. Well, ultimately a resolution occurred at the lower court, or at the trial level, if you will, and the defendants basically conceded that yes, there was an infringement, so let's try to get this thing settled. And so there was a what they called, or termed, a consent injunction. So a consent injunction essentially admits to there is a trademark infringement, and they consent to no longer use it. So that was the agreement. They were no longer going to use it, and the court was very specific in the ruling as to how it was no longer going to be used and what measures that this restaurateur had to impose, so to speak, in order to comply with the court order. Specifically, they were required to stop using, manufacturing, selling, offering, advertising, distributing any good or service or product using any simulation, reproduction, counterfeit, copy, or colorable imitation of any or all of Lamborghini's marks. So they took this mark fairly seriously, this Del Toro mark with the bull on it. I don't know, I think that maybe the Lamborghini kind of overreacted on this. I don't think anybody was really going to confuse the restaurant with Lamborghini, or how this would impact any of the sales of Lamborghini. If anything, in my opinion, it probably might have enhanced their sales. I don't know. But for Lamborghini to have launched a suit, I think was a little bit hasty and maybe unnecessary. But, I mean, the flip side of that is you really want to protect your trademark. Xerox ran into problems like this back in, maybe it was the 70s or 80s, when people said, I'm just going to Xerox a copy instead of I'm going to make a photocopy. Kleenex tissues also ran into a similar problem with people calling tissues Kleenex. So if you don't protect your trademarks and you're not protective of them, and bring such litigation, you may be in jeopardy of maybe ultimately losing your trademark. So Lamborghini's lawyers probably blew something in their ear and saying, we better file a suit on this just to show that we're protecting their trademark. So there was compliance to a degree. I mean, the compliance with regards to the court order, but then there really wasn't compliance, as they later found out that the defendants persisted in using the trademark, their own custom trademark, and they weren't really complying with the injunction. So procedurally, the defendants failed to comply with the injunction, and they were brought back to the district court of in Nevada because they were still displaying the mark, and they were doing various other things. They were supposed to actually destroy some of their materials, or actually all their materials that involved the trademark. So because they didn't do that, they didn't get rid of the trademark, and they continued to use it on their restaurant menus, so on and so forth, and decorations on their walls, they were hailed back into court, and the lawyers for Lamborghini enforced what was called a civil contempt proceeding, whereby essentially they didn't comply with the court order, so they were held in civil contempt, and part of the punishment was that they had to pay the attorney fees to Lamborghini for the cost of bringing these people back into court, or this entity. So essentially, civil contempt sanctions are employed for two purposes, the court noted: to coerce the defendant into compliance with the court's injunction and to compensate the complainant for losses sustained. Well, the big loss sustained by Lamborghini would be having their lawyers go into court and try to enforce this agreement that they had, this settlement that occurred in the underlying case. Pursuant to the terms of the settlement, the court went on, the plaintiff by contract is entitled to attorney fees and costs resulting from its efforts to enforce compliance with the injunction. So the plaintiff will also be awarded damages in accordance with the Lanham Act, and that's a little more of a detailed act. I don't really need to get involved in here, but if they can show any additional damages, they may be entitled to those damages. So the court, essentially, what they did was they ordered the plaintiff's, or they granted the plaintiff's motion to enforce the injunction and the settlement agreement, and to hold the contempt and for sanctions is granted, and that was further ordered that the plaintiff was to file a motion for damages and attorney fees within 21 days of the entry of the order. So bottom line in this case is, if you're going to use automobile marks in your own garage, that should be fine, but if you're engaged in some sort of a business enterprise or operation where you're using the marks, Lamborghini, Ford perhaps, Porsche, or any of the others, and you don't have consent from the owner of those marks or those trademarks, you may run into a legal problem. So bottom line, I suppose the moral of this story is just be on your guard, because some of these auto manufacturers are a little bit neurotic, and they will take you to court, and they will try to enforce their mark if they feel that you've infringed on their mark. So the takeaway from that is just to be careful, and maybe contact the actual company to see if you can get permission to do that. If you're opening up some sort of business, some shop, or a restaurant for that matter, or anything else there, you're considering to employ the mark of an auto manufacturer. Maybe if you're going to create watches, you may want to consult Porsche to see if they're going to let you use their mark on a watch. I know with Mustangs, the Shelby Mustang and that sort of thing, Shelby was very neurotic about enforcing his trademarks and his copyrights. It took a number of people to court while he was alive in his later years, and I believe he was somewhat successful in that endeavor. So just be on your guard. So that's all for this little episode. This is my first one, and hopefully the camera did its job and made this recording. I expect to be putting more up. Believe me, there's a lot of case law out there across the country with regards to auto accidents and liability and fraud and lemon law and so on and so forth. So part of this exercise is just to get the word out there to educate people about the law as it pertains to anything automotive related. So it's Richard Elslager here, work at Mahor Law Offices in the Chicagoland area and personal injury. And this, of course, I probably should have some sort of a little caveat in here that this is no substitute for seeking out the advice of a lawyer, that my commentary is for entertainment purposes only, and is not to be construed as any form of legal advice. And once again, consult a lawyer if you have any legal questions as it pertains to anything arising in your state. So that's it for now. It's late. Got back from practice not that long ago, so I'm running a little low on fumes. But that's it for now. Over and out. And I hope to put another video up in the next couple of days. Take care.